Welcome to day 10, session 2 of the virtual school on IP. The topic for this session is enforcement of copyrights in India. Our speaker for this session is Mr. Rohan Rohatgi, who is the founder at RSR Legal Advocates, which specializes in intellectual property laws, media and entertainment laws, e-commerce laws, as well as general litigation and transactional matters. Mr. Rohatgi has been practicing for over 10 years in India and has handled cases relating to trademark infringement, copyright infringement, designs infringement, defamation, right to privacy, injunctions, among others. He also advises clients on prosecution and enforcement of their intellectual property rights, as well as issues relating to e-commerce, as well as providing transactional support. Over the years, he has attended various domestic and international conferences talks in conjunction with the Chambers of Commerce and the Intellectual Property Office to educate the police officials as well as university students about intellectual property laws. It is indeed an honor to have you with us in today's session, and we welcome you, sir.
Thank you so much, Mona Lisa. Thank you for the kind introduction, and welcome to all the participants. I hope everyone is doing well. Should we begin, or should we wait for people to join in?
No, sir, you may start.
All right. Could we go on the first slide, please? So today's topic, as everyone knows, is about copyright enforcement in India. And so the copyright law is basically enforced through the Copyright Act 1957, which is a code in itself. In terms of today's whole webinar, we have divided this into four sessions, one being meaning of copyright and its infringement, various mechanisms available for enforcement of copyright under the Copyright Act, as well as the criminal laws like IPC, types of remedies that are available, and what are the challenges against enforcement of copyright which are being faced by the right holders. Next slide, please. So, what is copyright? As one is what all works form a part of copyright. There is literary work, there is artistic work, there is dramatic work, there is cinematographic films, and there is sound recording. Those are the works which basically over which they have the right holders have right. Now, there also the copyright is a bundle of rights, including the right of reproduction, communication to the public, adaptation and translation, performance or display of the work publicly, to prepare derivatives based on the actual copyright work, and in case of sound recordings, to perform the work publicly by digital auto transmission. Now, basically, what this would mean is, let us say there is a literary work like a book. Now, that book can be reproduced in an electronic form. For example, nowadays, a lot of you read books on Kindle. So that is being reproduced in another form. The work remains the same. It's still a literary work. The ownership still remains, the authorship and the ownership remains with the author. However, they also have a bundle of rights that they get along with that work, reproduction being one of them, then communication to the public. So, in terms of a book, by making it available to the public, it is communication to the public either through sale of the book physically or through electronic means or digital means. When we say electronic means, it could be wherein you purchase these books through platforms like Amazon and Flipkart, and where you download it, where you download the digital versions through Kindle and so on. Adaptation and translation could be the book is adapted into a play or a movie. So that is basically an adaptation. Like all of you know, there are various books which are converted into feature films. For example, Three Idiots was basically based on the book by Chetan Bhagat. So it was an adaptation of the book. Translation would as all of you would know, mean into any other language. Performance of the work would also include performance as a dramatic work. So these are some of the ways which the author has various rights over copyright. Next slide, please. Now, what can be protected? Like I mentioned earlier, the original expression of ideas, and it's very important to note the expressions of idea, not just the ideas. If you have an idea up here, very well, 100 more people have that. But how you express that, how it is fixated, is how you really get your copyright. So, like I mentioned earlier, literary, dramatic, musical, and artistic works, cinematographic films, and sound recordings are the form of works which are protected under the Copyright Act. Now, under these uh, works itself, there are various different kinds of categories of works which can be registered. For example, under literary, you can certainly register a book, you can register a software, you can also register uh, various. In the earlier days, you could also do a lot of databases could also be registered under the literary work. There used to be something called yellow pages, and there was a dispute regarding that as well. So these are the different forms of copyrights that do exist. I'm not going to go much into these since our focus is more on the enforcement of these copyrights than really what these copyright would entail or include. Next slide, please. Now, what rights can be enforced and how can they be enforced? So, under the Copyright Act, my apologies, there is a typographical error. It's mentioned as Copyrights Act. Uh, Now, there are two rights which emanate by your creation of a work, which are known as economic rights and moral rights. The bundle of rights that we mentioned earlier are basically economic rights, and moral rights mean, let us say, you assign the work to another party, who then become the owner of the work, wherein you continue to remain the author. The You still have a right to stop distortion or mutilation of that work, among other rights. So these are the two basic rights which fall under the Copyright Act. Now, it is certainly the responsibility of the copyright holder to enforce the rights, which primarily means the owner of the copyright. It shall come into play when an act of infringement takes place. Like mentioned earlier, it can either be an economic right or a moral right, and can be initiated by way of a civil suit or by way of a criminal complaint. Next slide, please. Now, the question is when and where to enforce these rights. Now, in order to enforce the rights under the Copyright Act, you can either file a civil suit for infringement in the relevant court having jurisdiction, or a criminal complaint can be filed either before the police authority or before the relevant metropolitan magistrate under Section 156 of the CRPC, 156.3 to be precise. Now, every suit or civil proceedings in respect of the infringement of copyright can be instituted before a district court or any court above the district court having relevant jurisdiction. This, I believe, falls under Section 62 of the Copyright Act, which deals with the uh, jurisdiction of the courts. My apologies, it is Section 62, not 60. And the interesting part about the jurisdiction is that it can be brought where the plaintiff resides or carries on their business. Now, when the section was really drafted, the outlook at that point of time was that most of the authors cannot be running around to get their rights enforced where the defendant is based, which is primarily what Section 20 of CPC provides. Therefore, going away from the normal rule of jurisdiction, a special rule of jurisdiction was introduced under the Copyright Act, wherein you can file a suit where the plaintiff resides or carries on business. What is interesting to note is this was emulated in Section 134 of the Trademark Act 1999, and they continue to be the only two IP statutes which provide rights to the plaintiff to file the suit in those jurisdictions where they reside or carry on business. Now, what is the limitation for bringing a infringement claim? As under the Limitation Act, it provides for 3 years from the knowledge of the infringement. Similarly, where the cause of action is continuous and recurring, it would be 3 years from the last date of such infringement that came to your knowledge. Next slide. Basically, this would mean that any action that you take should be taken at the earliest. Now, what is copyright infringement? Under the Copyright Act 1957, copyright infringement is defined under Section 51 of the Act, which primarily says that copyright in a work shall be deemed to be infringed on these grounds. I am not going to go into each of these grounds, but uh, majorly it means that if you are doing any act without a license, will be something which is uh, going to be in contravention of the act, where you've not taken a license from the author or the owner, as the case may be, therein is a copyright infringement. Even doing anything which is beyond the terms of your license could amount to infringement of copyright, where you are selling, where you are displaying or offering for sale or hire, or distributing any product, any sorry, my apologies, any work where you don't have a particular right from the right holder will amount to copyright infringement. Next slide, please. Even importation into India also amounts to the infringement of copyright if the infringing copy is being brought into the country. So there are various ways which a right can be infringed, and these are some of the definitions provided under the law in Section 51. Next slide, please. Now we come to what is known as fair dealing under Section 52 of the Copyright Act. Next slide, please. Fair dealing primarily means what is not constituted as infringement of copyright. Now, this is a very wide section and has multiple subsections, and it deals with a lot of issues. A very interesting case vis-a-vis fair dealing happened a few years back, which most of you would have been aware of, especially the students, was when Cambridge and Oxford filed a suit against Rameshwari Photocopy Service and the uh, Delhi University. Primarily, what was happening was that Rameshwari Photocopy Service was making bundles. It was basically copying from different books where the copyright was owned by Cambridge or Oxford, and I think there were one or two more publishers, and this was being done without paying any, either taking a license or paying any reprography fee. So they filed a suit that this is nearly an infringement of copyright, and so what was the defense taken by the photocopy service was that this is not an infringement of copyright because our law provides that, wherein you have the fair dealing provides that for education purposes this will not constitute infringement. Now the question that came in is, what amount of percentage can you really copy? Now in countries like the US and UK, if college students need to take copies of a book, they can only, I believe, I don't remember the exact percentage, but you can't do more than 8 to 10% of the book can be copied. Beyond that, you need to pay a certain license fee when you're getting that copied, and they're very strict about that. The libraries are very strict about that. However, in India, we do not have any such model. We provide that this can be done because this is for the benefit of the students who can't afford to buy such expensive ones books. So ultimately, the single judge of the Delhi High Court ruled in favor of the photocopy service, and it was held that this is not infringement of copyright. It went into appeal, but as I recall, the appeal was withdrawn. It was no more a simple suit of copyright infringement. It actually became something which was of a lot of public interest. Various associations, organizations, individuals implemented themselves into the suit. It became something more than just a copyright infringement suit, but a public right as it dealt with education. Now, as you would see, there are various exceptions that are provided under Section 52. I can't go into all of those. That will require a different session in itself. However, uh, criticism or review of a work or reading or recitation in public of reasonable tracts from published literary work, and even the publication in a collection of non-copyright matter, which is only for instruction use, can be also not constitute copyright infringement. Now, even if your performance of a literary, dramatic, or musical work by an amateur club or society, if the performance is given to a non-paying audience or for the benefit of a religious institution. Lastly, the storing of a work in any medium by electronic means by a non-commercial public library for preservation, if the library already possesses a non-digital copy of the work. So these are some of the examples which constitute which fall under fair dealing. There are various other the magnitude is very large. For example, usage of any document of the parliament or any legislation by you will not amount to copyright infringement. So these are some of the things which are very important to know, that what constitutes infringement and what does not constitute infringement. Next slide, please. Now we come on to moral rights. What are, like I mentioned earlier, apart from economic rights, the Copyright Act also provides for the enforcement of the moral rights, which are deemed to be the special rights. So Section 57 basically does not even use the word moral right, but it's known as the author's special rights. So as you would know, when a work is created, the author has, like we mentioned earlier, economic and moral rights. Now, there could be circumstances where the author sells all their economic rights. Basically, thereafter, they have no rights in the work. So, what remains with them is just the moral rights. Now, it is very common in the film industry where let's say, the music is given to the production house or the music production company. However, now in literary and musical works, they still retain some rights. However, when you create an artistic work, uh, that again you lose all your economic rights once you sell it. So what remains with you are just the moral rights. Moral rights basically are four in nature. One is what is known as right to paternity, which is to claim authorship over the work and have it attributed to the individual. This basically means, which is also known as a right of attribution, that even if I have sold the work, anytime when that work is used by the author, by the owner, you will attribute it to me that I am the author. You cannot remove my name from the authorship. So that to that extent, I can still claim that if someone has communicated any work to the public and they have not given my name as the author, I can still do that. Uh, I think this was also something which happened in terms of Three Idiots, which Ethan Bhagat had filed a suit, and right to paternity was one of the features of that. The other is the right of integrity, which basically means to prevent alterations, mutilation, or distortion and other actions that may damage the author's honor or reputation. as we would see, there's a very interesting case that happened in India in the I believe 1990s, which we will just go to in a few minutes. The other is the right to publication. The It is also a right with the author whether he would like to publish, not publish, or publish the artistic or literary work. And lastly, it's the general right saying not to have a work falsely attributed to him. So these are the four moral rights which basically the author continues to have even after they have sold or assigned the rights to another party. Next slide, please. Now, this was the case I was talking about. Is in terms of moral rights was Amarnath Sehgal versus Union of India. Was the first case involving the issue of moral rights in India, which was filed in the year 1992. So, Amarnath Sehgal was a very famous artist, and uh, at the entrance wall of Vigyan Bhavan, uh, closer to India Gate in Delhi, in the year 1962, when this was commissioned, there was a huge structure at the entrance, and that bronze mural sculpture of the Norse god, which took him nearly half a decade to complete, was inaugurated at it was part of Vigyan Bhavan, and it was there at the when you entered. It was You could see the work, and it was, I think, probably what, over 100 feet of wall. It was there all over the wall. Uh, Sometime in the year 1979, the mural was pulled down without his consent, and it was basically put in some godown. In 1992, finally, he then initiated an action against the government, the one that you could not do so, and if you did, you need to return it to me, and there's been a damage to my work, you need to compensate me. The court held in favor of Mr. Sehgal and identified the moral rights as the soul of the work. It held that the mutilation of the work is biased to the author's notoriety and reputation, and in an indirect way influences the social legacy of the nation. The Union of India was directed to return whatever was left of the mural, and it was specifically mentioned by the court that no rights remain with Union of India once the remnants go back to Mr. Sehgal, and there was an order for payment of damages and costs. So this was one of these cases which took place in terms of moral rights. The other very famous case was the case involving Pragati Medan, where when the Hall of the Nations was being dismantled, the artist who had put together the Hall of Nations filed a suit in the Delhi High Court. And though his moral rights were recognized, however, uh, I believe the case did not go in his favor. Next slide, please. This was this is part of the mural which was there at Vigyan Bhavan, which we were just talking about previously, which was taken down. Next slide, please. Now, in terms of the civil remedies available under the Copyright Act, are basically provided under Section 55 of the Act, and they can be filed along with Order under 39, Rule 1 and 2 of the CPC. So these are some of the injunctions, orders that you could seek under the Copyright Act. Next slide, please. First is the John Doe order. So the name John Doe is basically used to identify unknown and nameless defendants or infringers who have allegedly committed some wrong but whose identity is unknown to the plaintiff. It is kind of a cease and desist order to protect the probable loss due to copying and publishing without the author's knowledge or prior information. The name John Doe basically came, I believe, from the one of the cases in the US where the name of the party was John Doe, and that is how we started calling it John Doe orders. It is popularly known as John Doe orders, but in India it is also termed as the Ashok Kumar order. but I believe in normal parlance we continue to call it the John Doe order. It is usually issued for copyrights in movies, books, and sports events. So the one of the prerequisites of uh, the John Doe or seeking a John Doe order is that the plaintiff needs to prove a prima facie case with the balance of convenience and potential damage while establishment of proprietary rights of the owner. This was held in one of the cases in 2012. Next slide, please. So the Indian courts have followed the jurisprudence of the following English case while passing John Doe orders in India, which was the Bloomsbury Publishing Group versus News Group newspapers. They are four in nature. I will just read these out. First, the claimant needs to demonstrate that he has a good arguable case against the defendant. The stronger the order, no doubt, the stronger the case should be. Second, the order has to be in terms which clearly state what the defendant must and must not do. Thirdly, it must be possible to identify the defendant against whom the order is sought. Fourth, it will only be effective against a person who, when made aware of the terms of the order, will understand that it applies to him. So John Doe orders became very common when a lot of the publications, the production houses, when they go to court to get an injunction, a blanket injunction for seeking that the order, there should be a stay against the ISPs, the network service providers, and unknown parties, which are basically a lot of these websites available on the internet, who should be restrained from communicating these movies to the public illegally. And if they are found, then that extends to them. Next slide, please. So one of the first cases of John Doe order was way back in 2003, which was Taj Television Limited versus Rajan Mandal. Basically, Taj Television, which runs 10 sports, had the broadcasting rights for the Football World Cup back in 2002. So around 1,377 cable operators had taken licenses, but several prominent cable operators had not signed up and broadcasted the same without any approvals from Taj Television. The court basically held that while recognizing the unique nature of cable piracy and it being virtually impossible to enforce such rights, the Delhi High Court passed the first ever John Doe order and appointed court commissioners to search the premises of the other unnamed cable operators and seize evidence by taking photographs and the video. So basically, what John Doe orders really do is you can't keep running to court each and every time. So, in case you find a party who is infringing upon that work, you can extend the order to them and have them restrained. So this is basically what practically John Doe orders do. Next slide, please. Dynamic injunctions. Now, this is a very recent phenomenon in India. As way back in 2017-18 is when the first dynamic injunction was passed in India. It basically allows a right holder to approach the courts to extend the main injunction order against all mirror websites providing access to the same infringing online locations that were the subject of the main injunction. This injunction can be granted when the same website becomes available immediately after issuing the injunction with a different IP address or URL. The underlying objective is to help the right holder avoid the cumbersome process of filing a fresh suit and putting a control on websites, resurfacing with a different name, by extending an existing injunction to new websites which could emerge with a different name in the future. So this basically what it did was the way it's different from John Doe is John Doe, you don't know who it is. In dynamic injunctions, when you're filing the suit, you know who it is. However, you are also restraining the same party. Mirror websites is a very common phenomenon. You stop one, the other surfaces. So how does one stop those? So dynamic injunction gives you that right to really stop mirror websites from really again putting those infringing works online. So the first ever dynamic injunction was granted in UTV software and others in 2017 by the Delhi High Court. And as recent as in 2020, another injunction was passed by the Delhi High Court in favor of Disney. So these are usually in relation to movies, a lot of these cinematographic films, and prior to the releases of or after the release of the movies. Next slide, please. The third is the Anton Pillar order. Now, with Anton Pillar orders, they derive the name from the case of Anton Pillar KG versus Manufacturing Processes Limited. This order is primarily used in cases where there is a high probability that the defendant may destroy crucial evidence in his custody for the sole purpose of defeating the ends of the justice. So, to prevent this from happening, the plaintiff, on an ex parte application, even without notice being given to the defendant, can approach the court to enter the premises of the defendant for the sole purpose to preserve the evidence. It basically allows the plaintiff to enter the property of the defendant without his permission. Failure to give the permission will enable contempt of court and also empower the court to draw adverse inferences. This is very similar to appointment of court commissioners to seize uh, post an injunction. The Anton Pillar orders are very similar to, is basically like a search and seizure, and it is done to avoid destruction of evidence. Next slide, please. What are the prerequisites for an Anton Pillar order? In Bicruz Europe Limited versus Vulcan Industries Engineering Company Private Limited, there were again 3 points which were said to be the prerequisites. There should be, firstly, an extremely strong prima facie case. The potential or actual damages that can be caused to the plaintiff is very high. And there needs to be clear evidence that the defendant has incriminating documents in their possession, coupled with a real possibility that the defendants may destroy the same before an inter partes application may be made. So the Anton Pillar orders can also be issued by appointing a commission to make local investigation under Order 26 Rule 9 of the CPC. This we had already discussed earlier. Next slide, please. The other form of injunction is Bharava Injunction, which also got its name from a case known as Bharava Company Navaria SA versus International Bulk Carriers SA. It allows the plaintiff to restrain the defendant from removing assets from the jurisdiction or dealing with or parting with assets in such a way as to render the execution of the decree if given in favor of the plaintiff. It aids in the recovery of debts so as to help the creditor by preventing the debtor from absconding or disposing of his assets overseas. So Bharava Injunction could be usually more like a long arm statute. Some of the prerequisites of a Bharava Injunction are that there must exist a cause of action at the time the order is to be granted, and the plaintiff must demonstrate a good arguable case. The defendant must have assets within the jurisdiction of the court. The balance of convenience must be in favor of the plaintiff being granted the injunction. The plaintiff must establish that the defendant lacks probity and that there is a real risk of dissipation of assets. And lastly, there has been no delay in applying for injunction. Next slide, please. Rendition of accounts is another prayer that we always do when we are filing infringement suits. As a corollary to the injunction, equity may, in appropriate cases, require a defendant to account to a plaintiff for profits made from the act of infringement of copyright. It lets the owner seek the sum of money made equal to the profit made through unlawful conduct. Basically, the account is of net profits, that is sale price of the infringing article as deducted by the manufacturing and delivery cost. In one of the cases back in 1978, as mentioned here, the defendant was ordered to pay 20% of the profits to the plaintiff as the matter copied was less than 1/10 of the book. The plaintiff could be refused an account of profit if there are no profits, and in that case may claim damages for the losses suffered. Next slide, please. Then there are damages for conversion or delivery of infringing copies. Damages for conversion, as defined by Lord Atkin in the case, are damages for dealing with goods in a manner inconsistent with the rights of the true owner, provided that it is also established that there is an intention on the part of the defendant in doing so to deny the owner's right or to assert a right which is inconsistent with the owner's right. Section 58 of the Act entitles the owner of the copyright to initiate recovery of infringing goods along with all the plates used or intended to be used for the production of such infringing copies as they are deemed to be the property of the owner of the copyright. A plaintiff is entitled to offer damages or for an account of damages for account of profits, but not both. However, that has changed with now the advent of the Commercial Courts Act. Next slide, please. Now, what is the distinction between an account of profit or damages? Is that account of profits, the infringer is required to give up his ill-gotten gains to the party whose rights he has infringed. Whereas by the latter, that is damages, he is required to compensate the party wronged for the loss he has suffered. Next slide, please. So apart from the civil remedies, the owner of copyright can take criminal action against the infringer. It can be availed simultaneously with the civil proceedings to stop further infringement and punish the infringer. So civil remedies basically will injunct and also provide you damages and account for profits. However, criminal remedies will be could be bailable or non-bailable, and have obviously once arrested you go to jail. So obviously, criminal remedies have a much more higher impact, a serious impact compared to civil remedies, which are usually more monetary in nature. Section 63 to 70 of the Act deal with criminal remedies for copyright infringement. Section 63 particularly makes it an offense for any person knowingly to infringe the copyright in a work or any other right conferred by the Act, which could be even licensing, except the resale share right in original copies as provided by Section 53A, or knowingly to abet such infringement. The offense of an infringement of copyright is punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 3 years, with a fine which shall not be less than rupees 50,000, but which may extend to 2 lakhs. What was interesting, recently there was a case which said that because for infringement of copyright, the imprisonment is 3 years, could be termed as 3 years or more. Therefore, it is, I believe, a non-bailable offense is what the court held. Next slide, please. So, as per Section 64 of the Act, a police officer of the rank SI or above has been conferred with the power to seize, without any warrant, all copies of the work and all plates used for the purpose of making infringing copies of the work, once he is satisfied that an offense under Section 63 in any work has been or is being or is likely to be committed. Now, here a very practical issue arises, and a very different one from trademarks. So, the distinction between this and trademarks is here you can file a complaint, and on the basis of a complaint, a raid can be executed. However, in trademark law, under Section 1154 proviso, you have to seek, once you file a complaint for the your trademark being copied by someone, the police has to seek the opinion of the registrar of trademarks, which is not the case here. Though it is said that copyright accrues on the creation of the work, however, the reason we always suggest registration of copyright is when you need to enforce your copyright. At times, without registration, certain police officials refuse to take the complaint on record or then convert that into an FIR. So it is more for housekeeping purposes that at times you have a registration of a copyright. Though the law mandates that registration of a copyright is not compulsory, however, at times it does become easier when you have that registration, especially in terms of criminal remedies. Then these remedies are also available for infringement of broadcast reproduction rights and performance rights in India. Next slide, please. Also, the Act by virtue of Section 65 provides for penalty for any person who knowingly makes or has in possession any plate for the purpose of making infringing copies of any work in which copyright subsists, and shall be punishable with imprisonment which may extend to 2 years, and shall also be liable to fine. Now, another interesting thing here is that not only the person who is infringing the right will be liable, but anybody who is even, let's say, printing the, for example, let's say it's books, and you tell a printing press to publish the books for you, print the books for you. Now they have no interest in infringing, maybe, but because they are publishing those infringing copies, they also become liable for infringement of copyright and could be arrested by the police as well. Next slide, please. Now, there are some of the administrative remedies also available under the Act, which are primarily to deal with customs. Now, under customs, there are two ways that you could deal with. One is under the the Act and the rules under the Copyright Act, which are mandated here, which are provided here. The other is under the IPR rules 2007, which are enforced through the Custom Office. So, under Section 53(1) of the Copyright Act, the Commissioner of Customs is empowered to make an order prohibiting the importation into India of copies of copyright work made outside India, which, if made in India, would infringe copyright in the work on the application of the owners of copyright in such a work and or his agent. Now, the Rule 79 of the copyright rules basically provides that it requires the commissioner to take action under Section 53(2) and treat such infringing copies as prohibited goods. Next slide, please. Now, how does one do that? So, this is again mostly procedural. I would not go into that. I will go straight on to the IPR rules, which basically is what really assists in the stoppage of the infringing copies coming into the country. Next slide, please. Next slide, please. So the copyright rules that I was talking about, the IPR rules, this again deals primarily with what the Customs Act provides in terms of the border enforcement measures, which is done through Section 11 of the Customs Act. Next slide, please. Next slide, please. Mona Lisa, is anyone there?
So actually, I'm facing troubles. It's changing here, but it's not changing there. I'm trying to fix it.
All right, not a problem. So while we are facing those issues, apologies for that. We'll basically the intellectual property rights imported goods enforcement rules of 2007. They also provide for the registration with the custom office of a work in which copyright subsists. Now, by registration of the copyright with the custom office, by way through the whole procedure that is provided, once the just the one before this, please. Yeah. So, like I mentioned, you can file an application with the custom office, and once the whole procedure has been done and it is entered into the database, and you've provided for the bank guarantee and the bonds, the and now the very important aspect is by making of this application, you are covering all be it the air cargo, be it the land cargo, be it the sea cargo, anywhere where an infringing copy comes in, they can seize it, that this is an infringing copy, and then the procedure takes place. Next slide, please. Now, this is primarily the what the rules provide. Uh, Once you have provided the documents to the custom office, they will certainly verify it. And once the verification is done, a UPRN is issued by the custom office. And upon the generation of the UPRN, thereafter, you can also conduct there's some training seminars with custom officials to make them aware of your rights and what really to catch. And it's also important that so in the application you also inform them that who all are the people who are authorized to import into the country. So once that is done, they will never stop they will not seize any goods or work which is being brought into the country by the authorized parties. Where it's being brought in by unauthorized parties and which are not parallel imports could be stopped at the border. And thereafter, an action is taken under the IPR rules and the provisions of the Customs Act to seize those goods, and thereafter the destruction of those goods take place, and certainly a lot of demurrages and duty charges are payable by the uh, infringing party. The next slide, please. Again, next slide. Now, one of the most important parts of the one before this, please, yeah. So, enforcement in digital space in today is one of the most important aspects. Now, again, we most of the work is now available online. You know, all of us watch Netflix, Amazon, Hotstar, or we listen to music on apps like Spotify, Ghana. So today, and we read books online, like on Kindle. So slowly and steadily, though the physical works still remain, however, majority of the consumption of content is on digital space, and because of that, certainly there's a lot of infringement of work as well. Uh, so how do these acts deal with it, and how do we enforce these? So some of the orders mentioned earlier, like John Doe, Anton Pillar, Mariva, basically assist in uh, enforcing your rights. Next slide, please. So the Information Technology Act does play a role in combating digital piracy to a certain extent. Uh, what is very important is in 2012, the Copyright Amendment Act was introduced, which introduced Section 65A and 65B. Uh, and by introduction of these sections, we harmonized the copyright law with commonly known Internet treaties, which are the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. What is interesting is, though we passed uh, these laws in 2012 and they have been in the books since then, we ratified these treaties only 2 to 3 years back. So it was interesting that though we started following the internet treaties in our domestic law, however, officially we ratified them only maybe 7 or 6, 7 years after that. So what did these sections basically deal with is going to be very interesting. Next slide, please. So the provision under Section 65A of the Act sets out that any person who circumvents an effective technological measure applied for protecting any of the rights conferred in the Act with the intention of infringing such rights shall be punishable with imprisonment which may extend to 2 years and shall also be liable to fine. Now, effectively, what this means is earlier when you used to have CDs, you could copy the songs, let's say, onto your or the film onto your system. However, thereafter, now obviously we are kind of defunct with even the CDs. They started coming a system where you could not copy these onto your systems. Now, what is interesting is that you could not do that, right? But there were softwares available, or there were parties who were circumventing that measure, where you could bypass this technological measure and copy those songs or movies onto your system, which basically would amount to copyright infringement. So now, let's say you still cannot do it online unless you are subscribed officially. Let's say if you go onto a Netflix, you can only download and watch it on the app. You cannot download it separately. So that you're paying a certain license fee for. But all of them have adopted effective technological measures. For example, if you open up a music app, you can listen to the music. But if you want to download, you obviously need to pay a certain amount. However, if you are trying to circumvent such measure adopted by them, it could amount to copyright infringement. Section 65B of the Act states that if any person who knowingly removes or alters any rights management information without authority, or distributes, imports for distribution, broadcast, or communicates to the public without authority copies of any work or performance, knowing that the electronic rights management information has been removed or altered without authority, shall be punishable with imprisonment which may extend to 2 years, and shall also be liable to fine. Next slide, please. Now, this talks about basically what is known as the intermediary liability in today's time. And though every day the law keeps on changing with new judgments and new laws coming in, uh, what does the copyright law state and what does the IT law say to that effect? Now, the liability of the ISPs or the intermediaries under the Copyright Act is covered primarily under the fair dealing section, where it says that if there is a storage of any work which is said to be an infringing copy, then the ISP is not liable. However, that comes with a proviso that if the person responsible for the storage of the copy, for example, let us say that is Amazon, who is the intermediary, has received a written complaint from the owner of the copyright in the work, complaining that such storage is an infringement, such person responsible for the storage shall refrain from facilitating such access for a period of 21 days, or till he receives an order from the competent court refraining from facilitation, access, and in case no such order is received before the expiry of such period of 21 days, he may continue to provide the facility of such access. This was basically something which came in from the DMCA, the Digital Millennium Copyright Act of the US. Uh, there is a whole debate going on that should one always rush to court and get an order for this, or should we develop an administrative mechanism to make it much more easier for the right holders? Also, Section 79 of the Information Technology Act provides that no person providing any service as network service provider shall be liable under this act, rules, or regulations made thereunder for any third party information or data made available by him if he proves that the offense or contravention was committed without his knowledge, or that he had exercised all due diligence to prevent the commission of such offense or contravention. So, and what is the due diligence? You could say that they have softwares today. A lot of these intermediaries are now coming up with softwares to track these infringing copies. For example, YouTube is filled up with these, and they have created some mechanisms to stop infringement of copyright. So, Section 52(1)(c) and Section 79 needs to be read in tandem for purposes of enforcement. Next slide, please. These are some of the limitations against enforcement. One is certainly lack of awareness and attention. Various bodies like FICCI and SIPEM are doing a lot, but obviously in a country like ours, which is so huge, it will take time to create awareness. Certainly, what was there 10 years back, where the awareness was at a very low level, today the awareness is very high among the public and the corporates, and we hope it improves. The other was the delay in the adjudication of the civil proceedings, which has tremendously changed with the advent of the Commercial Courts Act, and I believe in the coming years it will increase more. One obviously is the unknown infringers. How do you really enforce these orders? Even if you get a John Doe, how do you really enforce them? Times becomes a big issue. Jurisdictional issues in copyright matters and trademark matters have been there, especially when you're filing composite suits. However, I think vis-a-vis copyright, it is still easy, but on the criminal side, you get issues at times. Also, difficulty in tracing infringement, which is very similar to unknown infringers. The other being multiplicity of suits and actions certainly could also be one factor. So these are some of the limitations that have been existing, and I think a lot of work has been going on through the government and bodies like FICCI, which are really trying to improve the systems. And thank you for that. So that's it from us. Thank you so much. If anyone has any questions, feel free to ask. Mona, do we have any questions?
Thank you, sir, for the insightful session. And dear participants, we won't be able to take questions for